what's in a name? I thought that I had this all figured out. I thought that I completely understood what a tax return is and that I didn't need to look into it more. Okay, but I'm not a probate attorney. I'm a real estate attorney. I'm a business attorney. I'm a tax attorney. But I don't do probates. Okay? So it's always been my understanding that tax laws should be construed strictly. And when I read the Connecticut general statutes to determine what qualifies as a tax return, I'm pretty sure that it is apparent by the plain meaning of all of the laws in Connecticut that tax returns are filed with the Commissioner of Revenue Services or the Department of Revenue Services or whatever you want to call it, the people who tax us in Connecticut, the people who we file tax returns with and make tax payments to. So we have this public act, which I've been talking about in my last couple of videos, because I already saw that it was going to be a source of frustration in a couple of closings that I have going on. And I've been getting different answers from different title underwriters, and I don't think that it's their fault. But I think that we need to, all of us, do a better understanding of how the actual law works in Connecticut and not be waiting an entire year after a law has gone into effect for lawyers and other professionals to explain it to us so that we understand what it says. Just in case you guys are wondering, I am a lawyer and another professional, and I'm explaining it right now. Okay, so feel free to tell me if you disagree in the comments below, but I think that a 706 NT is not a tax return. And if you think that a 706 NT is a tax return, which is one of the several things I've heard recently as they relate to Public Act 22-136 about this issue with inchoate liens and real estate in Connecticut. That's one of the several things I've heard recently where I think that someone is misreading the law or misunderstanding the law. Okay, and let me explain why. Okay, when I read Public Act 22-136, and I'm going to post the full language of this in the comments or the description of this video, but when I read this act, there's a section 3, a new section. Now, guys, I can't give you a Connecticut general statutes section for this new section of Public Act 22-136 because I haven't found it. Now, if you go looking for it and you find it, please let me know if it's been incorporated into the Connecticut general statutes yet. But basically, since we have code law in Connecticut, for those of us who don't know, we have a code, like just sort of like the federal government. And I think most states are probably like that. And what happens is we have our official general statutes. And when a new law is written, just like on the federal level, it's somebody else's job to take that law and figure out where it fits in the old law. And sometimes the new law will say we're amending a section. But sometimes they're like, hey guys, brand new section. And then some government employee's job to actually take that and put it in the Connecticut general statutes. Okay, so that's why I don't have a Connecticut general statutes section for this yet, but there will be one at some point. And this new section of Public Act 22-136 refers to other Connecticut general statutes sections. Okay, and I'm going to read it now. I'm going to read section B, because section 3B is the section that I think sort of is the main rule here. Because when you're reading a law, you have to look for certain signal words. And one of those signal words when you're reading a law is the word notwithstanding. And notwithstanding means that look at everything else in here and disregard it. If it conflicts with what I'm about to say yes, then what I'm about to say yes is the rule. So it says in section 3B of this Public Act 22-136, it says, notwithstanding any other provision of Title 12 of the general statutes, so I guess this is probably going to go in Title 12 somewhere, right? And Title 12, by the way, is the tax title of the Connecticut general statutes. All of them. Okay, so it's referring to any tax, and it says, notwithstanding any other provision of Title 12 of the general statutes, any lien imposed upon real estate situated in the state for the tax imposed under Chapter 217, and that's the estate tax, I think probably formerly the succession tax. I don't know, guys. I'm not an estate planning attorney. What do we call it these days in Connecticut? Succession tax? Estate tax? There's some things that I don't know and some things that I do know. But I do know how to read laws, right? So it says, Chapter 217 of the General Statutes, which is that estate tax, okay? This is the inchoate lien I've been talking about. As in effect for December 31st, 2004, shall be deemed released 10 years. Okay, so far we have this section saying, it doesn't matter what the rest of the tax code says. So the rest of the tax code is where the inchoate lien comes from, okay? It doesn't matter what the rest of the tax code says. But any lien that's on real estate in this state, because of the estate tax, or any tax imposed under the estate tax, well, it's going to be deemed released 10 years after the date of death of the decedent. Okay? So, that first part, that 10 years, this is Connecticut trying to bring things more in line with the way the federal government works, maybe some might say. Although, if there's an unfiled tax return on the federal government, then generally there's not a restriction on assessment. So I don't think that's really what's happening here, but some people might say, we're changing it so that's the 10 years. Oh, my timer's going off. But I don't think that that's what's happening here, okay? But so what? So 10 years. I think 10 years is just a convenient period of time. Somebody would have said something by now. We're not going to do anything about it anymore, right? So it's going to be deemed released 10 years from the date of the death of the decedent. Okay, so that's the general rule. And then there's a comma, and it says, except for... So here's the exception to this broad general rule that they're going to be deemed released 10 years after the date of death of the decedent. And then it says, except for estates that have filed a return or been assessed a tax under Section 12-392 of the General Statutes prior to 10 years from the date of the death of the decedent. Okay? So a 706 NT is a form that looks like an estate tax return that is not filed with the Department of Revenue Services. It's filed with the probate court to say, we don't have to file a tax return with the Department of Revenue Services. It is not a tax return. But if you disagree with me, please tell me, because then I've been reading this law wrong. And, I wish that I wasn't. I don't even think this is a question of a difference of opinions. I think it's a question of whether or not people have looked closely and carefully enough. And fine, if I haven't looked closely and carefully enough and you can point me to a law that says this is a tax return, then I want to see it, because I don't see any laws that say a 706 NT is a tax return, and I really don't think that it is under the plain meaning of the laws. And if a 706 NT is not a tax return, then this exception to this general rule in 3B does not apply. But what I'm hearing now, the most recent email I've gotten from an underwriter dealing with this estate that I'm dealing with, is that a tax return has been filed because a 706 NT was filed. But guys, that's not how it works. Okay? There's a fake lien. It only exists because we don't know if there's a tax liability. Our government has said that in 10 years after somebody died, if we don't know and something's not in process or already assessed, then it's deemed released. Okay? So that means that, look, if you file a return, sometimes a tax isn't assessed yet. Maybe you just filed the return, so the tax isn't assessed yet. It's about to be assessed. Okay? That's the piece that people are missing here. It's not for estates that filed a probate. If they wanted to say for estates that have been opened or filed a probate, they would have said that. But they said whether or not a return has been filed. And a return hasn't been filed for estates that file a 706 NT, because that's not a tax return. So I hope that helps explain my position on this topic. I'd love to hear if people disagree. Could somebody point me to some actual authority as to why they disagree if they do? I am not fighting with this with these title companies. Just so you guys know, I'm getting them what they want. It's just taking a little bit longer. And it's one of those things that I was talking about in my post the other day. Sometimes when you're mad at your real estate attorney, they're just fixing something. And sometimes they're made up problems. Actually, a lot of times they're made up problems. But People are going to have different opinions on what is a problem and what isn't a problem sometimes in real estate. And sometimes the path of least resistance and the quickest way to close a deal is to not fight over it. So why do I share this with you? Because it's important to keep that context in mind when you're dealing with other professionals in the real estate industry. That sometimes we're just trying to get through, and we don't always agree that something is needed. And we could fight people, or we could get along and make sure that everyone feels comfortable with the transaction. And my preference is usually whichever one is quicker. Thanks for listening. Have a great day.